Good afternoon. My name is Anine Lambert. I'm a member of the North Dakota Law Review. Our next speaker is Ms. Melissa Grobler. She is an associate attorney at Steptoe Johnson and will be speaking today about a North Dakota case that impacts title examination and assignment of pre-existing obligations imposed by a predecessor of title. Ms. Grobler received her JD from the University of Houston and works in energy law, including conducting title examinations and performing due diligence on multi-million-dollar acquisitions. Ms. Grobler regularly works on leases, operating agreements, easements, and advises clients as to the implications that legal agreements may have on operations. Ms. Grobler provides advice to clients seeking to clear title before commencement of drilling and is highly qualified to answer any of your questions about the title examination process. Please join me in welcoming Ms. Melissa Grobler.
That was quite an introduction. As indicated, I'm here to speak about A.G. Golden versus SM Energy Company, which is a recent decision from the North Dakota Supreme Court, actually as recent as February of this year. The basis of this topic is to discuss what the scope of title examination is with respect to assignments when they're taken in the context of pre-existing affirmative obligations which are imposed by predecessors of title. The important questions here are when are assignees demonstrating intent to be bound by affirmative obligations, and when are assignees charged with notice of affirmative obligations. We'll begin with the facts of the case. A.G. Golden owned leases covering property in McKenzie County. On July 15, 1970, Golden entered into a letter agreement with Universal Resources Corporation, wherein Golden sold Universal its entire interest subject to a retention of a 4% overriding interest. The 1970 letter agreement created what is called a joint area of interest. It included all of sections 19, 20, 29, 30, 31, and 32. The letter agreements included provisions wherein A.G. Golden, if he was to purchase any leasehold interest in that area of interest, he would offer it to Universal, subject to that same reservation of 4% override. Conversely, Universal, if the company were to purchase any leasehold interest in that area, they would assign a 4% override to Golden without cost. They agreed that if there was production on the land, the obligation would continue so long as the production continued. And the really important part of this is that they also agreed that the term extended to any new leases, lease renewals, lease extensions, and that any subsequent assignment of this agreement made by Universal would recite that it was made pursuant and subject to the terms of the letter agreement. So Universal had to agree that if they were to assign their interest, they would make it subject to the 1970 letter agreement. Thereafter, Universal acquired several leases in this joint area during the early 1980s, and they did assign a 4% override to Golden in those leases, specifically including a lease called the Thompson lease. April 29, 1993, Universal sells to Tipperary Petroleum Company its interest in the leases and lands covered by the letter agreement. The important provision, which we'll come back to because this is what the court really has focused on, is that this assignment's provision included that Universal is assigning all right, title, and interest in and to the operating agreements, joint venture agreements, partnership agreements, and other contracts to the extent that they relate to any of the assets. This becomes the provision that the Supreme Court really focuses on. Months later, Tipperary acquires all of Texaco's interest in what they call the federal lease, and this becomes important later on. Then in 2000, Tipperary sells all of its interest in the leases and lands subject to the letter agreement, including the Thompson lease and the federal lease, its contract rights, its obligations in that letter agreement to a company called Nance Corporation. In that assignment, Nance assumed all of the Assinor's duties, liabilities, and obligations relating to the assets to which Asinor was a party of, by which it was bound on and after the date hereof. Then Nance merges into SM, who is our current defendant. And that brings us almost to the point of the dispute. SM is currently the operator of a Thompson federal well and a Wilson well. The drill spacing unit for the Thompson federal well includes both the Thompson lease and the federal lease. The Wilson well is located within the joint area of interest as it was defined in the letter agreement. So where we are now is that SM has been paying Golden royalties on production from the Thompson Federal Well as it's attributable to the Thompson lease, but not as it's attributable to the federal lease. SM is paying Golden a 4% override on production from the Wilson well, but only since 2009. It has refused to pay for earlier periods of time because SM's previous smaller payments were made under an executed division order. So then Golden brings this action to determine the parties' rights. And just to give you a little recap of what's happened here, because there's a lot going on, AG Golden conveys to Universal with this letter agreement. Universal then acquires interests, including the Thompson lease, and assigns a 4% override to AG Golden. Universal then gives to Tipperary. Tipperary acquires an interest in the federal lease. Tipperary gives to Nance Petroleum, and Nance Petroleum turns into SM Energy, and that's where we are today. Golden brings this action to determine the parties' rights, to quiet title in the interest, and to get an accounting of the proceeds. At the district court level, the district court grants summary judgment, saying that AG Golden and other plaintiffs are entitled to a 4% override in the leases and lands covered by that 1970 letter agreement as a matter of law, holding that SM, through its predecessors, expressly assumed Universal's rights and obligations. The district court also holds, on summary judgment, that SM owes Golden retroactive royalty payments on production from a well located on the subject property, this being the Wilson well. Finally, at the district court level, the judgment expanded the scope of the ruling beyond the pleadings to include all leases and all wells in the joint area of interest. They also denied SM's post-judgment motion to amend and for relief of judgment. So SM, when they come to the Supreme Court, argues that the district court erred in granting Golden summary judgment because as a matter of law, neither SM nor its predecessors actually assumed the joint area of interest clause in that 1970 letter agreement. Interestingly enough, the parties agree that the area of mutual interest clause is not a covenant that runs with the land, and that becomes an important issue in the case, but is instead a personal covenant which is enforceable only between the original parties to the agreement. The parties also agree that SM and its predecessors in interest must have actually agreed to be bound by the AMI clause for it to be effective against them. The district court focused on that 1993 agreement between Universal and Tipperary, which had provided, and this is the important language, Universal assigns all right, title, and interest in and to the operating agreements, joint venture agreements, partnership agreements, and other contracts to the extent that they relate to any of the assets. So Golden argues that this provision in the 1993 agreement between Universal and Tipperary unambiguously establishes that SM assumes the area of mutual interest clause because Tipperary acknowledged when it acquired those leases from Universal that the acquisition was subject to those terms of other contracts that relate to the conveyed leases, and that those other contracts include the 1970 letter agreement, and therefore that letter agreement, including the area of mutual interest clause, relates to the assets conveyed. SM, on the other hand, argues that the provision unambiguously establishes that they did not assume the AMI clause because the assignment reflects the parties' intents to carefully limit the terms of the assignment to the extent that they relate to the leases being assigned, and the AMI clause does not relate to those properties. Universal had previously acquired and was assigned to Tipperary, and SM argues that that AMI clause only applies to properties that Universal chooses to acquire in the future. So the Supreme Court of North Dakota includes lines of reasoning which include that an assignment of contractual rights does not necessarily carry with it a delegation of contractual duties, even if the assigned contract specifically says that it's binding on the assigns of the parties to the contract. And where an assignee of a contract makes it known to the assignor that it does not intend by accepting the assignment to assume the assignor's duties and obligations, those duties and obligations are not delegated, and the assignee makes no implied promise to perform them. Lastly, the mere assignment of a bilateral executed contract cannot be interpreted as a promise by the assignee to assume the performance of the assignor's duty. The Supreme Court says, though, that where it's clear from the intent of the parties, the assignee also succeeds the obligations of the contract. So where that leaves us is that simply by executing an assignment, which is subject to the terms of a previous obligation, the assignee doesn't necessarily automatically accept the terms of those contracts. Instead, they have to intend or affirm that they're going to accept the terms of those contracts. And the Supreme Court tells us that intent can be manifested in 4 ways. It can be manifested by the party's conduct, the subject matter of the contract, the language of the assignment, or the surrounding circumstances. And in fact, the court says we will always consider the totality of the fact situation. The Supreme Court tells us that an assumption of obligations may be implied from an acceptance of benefits or the performance of duties under the contract. So another way in which an assignee can indicate that they intend to honor the terms of a previous agreement is by acting on the terms of the current agreement. As a general rule of contract law governing assignments, if an assignee takes an interest in oil and gas leases and the document of conveyance states that it is specifically subject to the terms of a contract wherein there's an area of mutual interest, the assignee operates under the terms of the contract, then it is submitting that it has assumed the obligations of that area of mutual interest, and that area of mutual interest will thereon be enforceable against them. Whether or not these obligations are assumed by a party acquiring oil and gas leases subject to an area of mutual interest is a question of intent. It appears that from here on out, that's always going to be a question of intent, and all of the surrounding circumstances will be evaluated subject to that intent. The district court adopted Golden's interpretation at the district court level, concluding that the letter agreement was a contract which related to the leases and lands covered by the assignment, and therefore the rights and obligations under that letter agreement were transferred from Universal to Tipperary. The court did not address the to the extent language argument that was relied upon by SM. The Supreme Court concludes that the contested provision of the 1993 assignment is ambiguous, and that the district court erred in interpreting this provision as a matter of law, meaning that the district court needed to have heard all the facts and they needed to decide it as a question of fact. The district court concluded that the summary judgment in favor of Golden was proper because the letter agreement was recorded, and therefore Tipperary had constructive knowledge of the existence of its terms. In fact, every documented issue in this case was recorded, so every subsequent successor to interest had some type of constructive knowledge of the previous agreements, including all of the terms of the previous agreements. The Supreme Court disagreed with the district court, although, and said Tipperary might have had constructive notice, but the question is not whether they had constructive notice, but whether or not they had agreed to be bound by those terms. So SM was a predecessor to Tipperary, and the Supreme Court asked not whether or not SM had some kind of notice of the existence and the terms of the agreement, but whether or not they actually affirmatively agreed to be bound by those terms. The district court ruled that Tipperary was bound by all the obligations imposed by that letter agreement under North Dakota's Century Code Section 9-3-25, which provides that voluntary acceptance of a benefit of a transaction is equivalent to the consent of all the obligations arising from it, so far as the facts are known or ought to be known by a person accepting. So the North Dakota Century Code Section 9-3-25 essentially says that at the point at which you consent to the transaction, you accept the benefit of that transaction, you are indicating that you intend to be bound by all the terms of subsequent assignments. The district court adopted Golden's argument that just by executing the 1993 assignment, Tipperary was voluntarily accepting the benefit, that the mere act of entering into the transaction was the voluntary acceptance of the benefit. The Supreme Court disagreed with this interpretation. They said the construction and interpreting the North Dakota Century Code language in that way would destroy and obliterate the requirement that an assignee consents to be responsible for the obligations of the assignor. It would turn what is otherwise a personal covenant into a covenant that runs with the land. And if you remember, the parties in this case agreed that this was not a covenant that ran with the land, but instead was a personal covenant between the initial parties. Supreme Court reasoned that when the North Dakota Century Code refers to facts, when they say that all the obligations arising from it so far as the facts are known or ought to be known, that those facts actually mean extrinsic evidence of conduct after the completion of the transaction that suggests a voluntary acceptance of the benefit. And the Supreme Court reasoned that neither the district court nor Golden provided any evidence of SM's conduct that is inconsistent with its own interpretation of the assignment, meaning that after the transaction, SM didn't do anything to indicate that it was aware of and choosing to apply or choosing to be burdened by the terms of the agreement. Tim Dowd has written a really great paper on this, and he talks about unrecorded material agreements and the purchase and sale of properties, and it gives us a little bit of additional insight. Whether a party is bound to an AMI agreement depends on a number of different facts. The third one that he lists, which is really applicable to us here, is whether or not the agreement is a covenant that is going to run with the land or whether or not it's a personal covenant. On that issue of whether or not the agreement is a covenant, we have two Texas cases which address the subject. They're decided a year apart, and they completely disagree with one another. So in Westland Oil Development Corporation, the Supreme Court of Texas held in 1982 that in an area of mutual interest provision related to, touched, and concerned the leases in existence, and therefore there was privity of estate between the parties, and it was a covenant running with the land. The details and the fact situation in this case gets very complicated, but I'll give you kind of a brief, superficial analysis of them. If it's something that you're interested in, the facts are worth looking into due to the complexity of the fact situation. But in this case, the court had to determine whether or not a letter agreement, what effect a letter agreement had upon an interest in leases. In this case, Mobil owned oil and gas leases in a section and entered into a farm out with a company called Westland. Another company called Chambers and Kennedy sought to take over Westland's obligation in that farm out, and they agreed to do so in a letter agreement. The agreement contained an area of mutual interest agreement, which required that any leasehold interest acquired in that area would be subject to the terms of the letter agreement. Subsequently, the parties enter into an operating agreement, which contains a recital, and in that recital, they decide that in the event of any conflicts between the operating agreement and any other number of agreements, including the original letter agreement, the terms of the prior agreements would prevail. So a third party, Hansen, obtains a farm out, and he assigns his interest to Gulf and Superior. Gulf and Superior start producing on the land, and they earn the leased acreage from Mobil. Mobil makes an assignment of the leased acreage to Gulf and Superior. Westland, who is an initial party and original party to this ordeal, then sues seeking a judgment that the letter agreement was valid and applies to the interests that Gulf and Superior acquire. And in this case, the court holds that a purchaser is bound by every recital, reference, and reservation contained in or disclosed by an instrument, which forms an essential link in the chain of title. So anytime you're reading an assignment and it says, subject to that agreement between Asinor and Assinee, effective July 1st, 2000. In Texas, according to this case, any purchaser is bound by that agreement, whether it's recorded, unrecorded, whether they can get a hold of it, regardless of what the terms of that agreement are. If it's in the chain of title, they're bound to it. The rationale behind that decision was that any description, recital of fact, or reference to other documents puts the purchaser upon inquiry notice, and he's bound to follow up until the entire series of title deeds is exhausted and a complete knowledge of all the matters referred to and affecting title is obtained. It's a very drastic approach to take for the Texas Supreme Court. They're telling you that anytime you see a reference to any document within your document, you're on inquiry notice to exhaust a search to determine what the terms of that agreement are. And simply not making the effort to exhaust that search is not sufficient. You can't say, well, I didn't know, I didn't see it. If it's there, you are put on notice and you have to exhaust your search to determine what the terms of that document say. And thus, the court ruled that it was the duty of Gulf and Superior to make an investigation of that agreement, which made a clear reference. Then we have a case 1 year later out of the Appellate Court of Texas called Grimes versus Walsh and Watts. And this case comes out almost completely opposite, holding that an AMI covenant, which is not expressly binding on successors and assigns, is a personal covenant, which completely flies in the face of the previous court decision, which had said that AMI clauses are covenants that run with the lands. This is a little bit of a different fact situation, and I won't get too much into it because it's hard to follow. But essentially what the court decides is that where there is no successive chain of title or relationship, you can't establish a covenant as running with the land. So it has to be a clear, flawless chain of title between the parties in order for there to be privity of estate between the parties. So if there's any break in the chain of title, you no longer get that protection, and your covenant is going to be a personal covenant between the original parties. So going back to the Golden case, the district court also decided another issue, which was that, as we discussed earlier, let me get back to that so we're following it. So SM was paying Golden a royalty on a Wilson well. The Wilson well hadn't been any leasehold interest that Golden had ever owned, or that successors in interest had ever owned up until SM. SM owned an interest in this Wilson area. It was, however, part of the joint area of interest. And at the district court level, the district court decided that SM owed Golden retroactive royalty payments on the Wilson well, one, because it was in the joint area of interest, but two, disregarding the fact that SM had executed division orders which said that it didn't have to pay. So SM here before the Supreme Court is arguing that the district court erred in that award, in awarding Golden retroactive royalty payments, and SM argued that there's a decision on point in North Dakota that gets them out of it. The decision is Acoma Oil Corp. Versus Wilson. And in that decision, the court decided that a working interest owner is not required to compensate royalty owners for underpayment if they executed a division order stating the percentage upon which they were to be paid. Now, the fact situation in Acoma is a little bit different. In Acoma, a well operator overpays and then underpays some of its working interest owners. But ultimately, it pays out 100% of the well proceeds under both a title opinion and executed division orders by the working interest owners. The well operator contends that it is not liable for underpayment in that case because it received no benefit. I mean, it ultimately paid out 100%, so when it received no benefit and was not unjustly enriched, the well operator contends that it's not liable. And the court agreed with them in Acoma. The court said that detrimental alliance is why purchasers and operators are usually protected by the rule that division orders are binding until revoked. And in a typical case, purchasers and operators following division orders pay out the correct total of proceeds, but they earn the distribution. So instead of paying someone 49%, they're paying someone 51%, meaning that someone's going to be overpaid and someone's going to be underpaid. If an underpaid royalty owner's suit is not stopped, the purchaser-operator would have to pay the amount of overpayment twice, once to the overpaid royalty owner and once to the underpaid royalty owner. That amounts to double liability for the amount of the overpayment. And generally, underpaid royalty owners have this alternative remedy. If you've been underpaid by an operator-purchaser, you can recover from the overpaid royalty owner on the basis of unjust enrichment. So North Dakota in the Supreme Court in Golden distinguishes the facts of Acoma from the facts at hand. In Acoma, it did not hold that a well operator is automatically insulated from liability for the underpayment of royalty simply because the incorrect payment was made in accordance with an executed division order. Acoma is distinguishable because here SM is the well operator that prepared the division order, and SM is also the overpaid working interest owner. So in the previous case, we had an operator paying to working interest owners 100% of the proceeds, but messing up the distribution. Here we have a case in which SM is the operator and a working interest owner, and by underpaying Golden, they're overpaying themselves, so it's a different situation. Thus, Golden suffered some harm and SM was unjustly enriched, meaning that they retain the benefit of this erroneous division order. Doesn't matter that Golden signed a division order saying what they were owed. Ultimately, SM is benefiting itself by underpaying Golden. And lastly, SM argues in this case that the district court erred in granting Golden relief as to other lease interests and properties which were not the subject of this litigation. So what happened is that Golden prepared the judgment at the district court level. The court entered a ruling, Golden prepared the judgment, and in doing so, Golden just expanded the scope of the judgment. The judgment initially, or the ruling initially, was as to these leasehold properties, here's our judgment. When Golden prepared the judgment, they said, as to all leaseholds' interests in this joint area of interest, this is going to be the judgment. And when they did that, the district court acknowledged it. The district court said, we recognize that Golden has expanded the scope of our ruling by providing this judgment, but nevertheless, we're going to approve it. And in saying so, they said that it makes no sense that the plaintiff would have to relitigate this case for every single leasehold interest in this joint area of interest. The North Dakota Supreme Court saw this and ruled that the district court cannot do that. They can't grant relief based on issues that weren't pleaded or litigated. The legal status of any of the additional leasehold interests in this joint area of interest aren't voluntarily litigated by the consent of the parties. And the case involves property interest, and the complaint initially was to quiet title. So the expanded judgment can't be binding on any person who wasn't there to initially plead their interest. And so the district court therefore erred in approving the expanded judgment, which includes unpled and unlitigated cases. So really, the important take-home from this case is that the Supreme Court is falling somewhere along the spectrum in terms of, as a title examiner, to what extent do we have to pay attention to collateral documents? How important is it as a title examiner that when you see an assignment with an unrecorded or recorded document, that you put your client on notice of that document? And it seems to indicate here that the North Dakota Supreme Court is saying that successors in interest don't necessarily or automatically assume all obligations in previous agreements. And that's a big and an important ruling, to say that a successor in interest really has to show an intent to accept the terms of previous agreements. As we saw in Texas, they've kind of decided the opposite. They've determined that successors in interest are put on notice, and if for example, if an AMI clause is a covenant that runs with the land, that they are automatically going to accept the terms of that clause. So I think going forward, this is going to be an open question. The Supreme Court remanded the issue back for a fact determination because the initial case had been decided on summary judgment as a matter of law. So the case is going to go back to the district level, where they're going to have to look at the totality of the circumstances. They will have to determine whether and to what extent SM has shown any intent to assume the obligations in the initial letter agreement. And those four areas of intent are definitely going to play a part going forward, but it is something that has really triggered a red flag for title examiners going forward, especially given the ruling that record notice is no longer all you need. Having record notice is no longer determinative in terms of accepting these pre-existing obligations. So getting to the point that you're going to have to show intent is really going to be a deciding issue for title examiners going forward. And I've run very short, but Morgan tells me that she's really excited to go and get us to happy hour. So I'll let her do that. Thanks, y'all. Appreciate it. And if anyone has any questions, I guess that's what this time's for. All right. Thank you so much for the opportunity. It was really a pleasure. And my contact information is here if anyone has any follow-up questions, and I'll turn the floor over to Morgan. Thanks.